get started, I think we are good to go.
Great. Great.
Okay, hi everyone. I'm Sybil Gurney. I'm the Assistant CIO here in Alameda County in California. I'm joined by Debbie Stadamir, and who is our NACo, my NACo co-presenter or co-moderator, I should say. And then we have our presenter, Devin Schwastik. Devin Schwastik is a member of the law firm McNee, Wallace & Urich, based in Harrisburg, Pennsylvania. He's the chair of the firm's privacy and data security practice. He advises clients on compliance in emerging federal, state, and international privacy laws, and he is going to be our presenter today. And he is going to, he would like this presentation to be interactive. So if you have any questions, just enter them in chat, or we're going to try at some point, raise your hand. We'll try and take live questions as well. So with that, Devin, take it away.
Thank you, Sybil. Thank you, Debbie. I appreciate it. Great to be here with you, and thanks to the National Association of Counties for the opportunity to speak to your membership on a cybersecurity topic. I've been working in the cybersecurity space for about 15 years now, originally as a litigator representing companies in data breach litigation, and my practice now is largely centered on advising businesses, organizations, governmental entities, and others on compliance with emerging privacy laws and best practices to secure their important and sensitive data. And today I was asked to speak about cybersecurity terms for contracts. And I certainly do have a few slides that I can work through today, and happy to do so to give some examples of the key issues on which there are often intense negotiations in vendor contracts. I have represented many of our counties here in Pennsylvania on cybersecurity issues, including negotiation of vendor contracts. And so I can come to you with that level of experience on what the sticking points are in those negotiations and what counties should be looking for to best protect themselves and their residents and other stakeholders. But when I was talking with Rita Reynolds last week in preparation for today, she thought I might be best served by giving you an anecdote from one of my recent cases that I've handled for a municipality, because I think that this scenario really brings to light some of the key issues and emphasizes why these are points of concern for counties and other entities in negotiating contracts with vendors and attempting to protect their data. So I'll tell you that last Monday, I got to the office and received a call from one of our municipal clients. Their business officer had arrived at the office that Monday morning and was unable to log into their financial systems. So they called us here at McNeese, and we're often the first call for our clients who are trying to figure out what might be going on. They sent me a screenshot of what appeared on the screen, and it was immediately apparent that the county's network had been afflicted by ransomware. Ransomware is, of course, a type of computer virus or malware that is installed on a computer and locks down the files with a complex encryption code that prevents the owner of those files from accessing them or otherwise logging into their systems and utilizing their computer networks. So we started to explore the situation, and this municipality unfortunately found itself in a rather precarious situation because of a lack of diligence in its efforts in negotiating its vendor contracts. So the first thing that we did was get in touch with the vendor that administers their networks and provides their IT security. And they swung into action as best they could, but unfortunately, the criminal gangs that distribute ransomware are generally very sophisticated, and the computer code that's used is, generally speaking, unbreakable. And this was a particularly new ransomware variant, a version of the Ryuk ransomware that's been prevalent, but a new version of that. And not a type of malware that anyone has ever discovered any secret key to. There's no shortcut and no way to come to the rescue with any kind of decryption program to enable them to unlock their systems. So we started exploring what the possibilities were for them to remediate that scenario and get their systems back up and running. And generally speaking, the options that an entity afflicted by ransomware has are, number one, pay the ransom to the bad guys in order to get them to provide a decryption key, or number two, try to restore the systems from backup. So we talked to the IT vendor, and over the course of the next day or so, as they were exploring their options and what they were able to provide, what we found out was that the last backup of that municipality's financial systems had been downloaded and stored remotely in 2018.
Oh.
So there was no possibility of restoring from backup and coming anywhere close to current with any of the information about payments, tax revenues, and everything else, that payroll, everything else that went into their vendor payments, everything else that went into that financial system. So they were left on that side of things, exploring the possibility of trying to restore from that 2018 backup and then manually data enter all of the payments ingoing and outgoing from 2018 to 2020. Obviously, that's an incredibly daunting task, complicated significantly by the fact that much of the records of those payments, including payroll, were not kept in paper form as a supplementary backup. So, it appeared to us after the first day that backup was not going to be an option. Restoring from backup was not going to be a realistic option, and instead we started looking at whether or not we were going to be able to try to negotiate with the bad actors in order to try to obtain a decryption key. And I can tell you that the initial ransomware demand from the bad guys was $5 million. So for this municipality, it wasn't a county, smaller municipality, that obviously a significant sum of money, and potentially just not within the means of that municipality to pay. We do work with some very good IT security vendors, and at that point we had hired an outside security vendor to come in and take over the investigation from the local IT firm that had administered the network. We essentially lost confidence in that local IT vendor when we discovered that there were no backups except from 2018. And the IT vendor that we retained on behalf of that municipality has entered into negotiations with the bad guys. They're criminals, cyber criminals, most likely from Eastern Europe or Asia, somewhere outside of the United States jurisdiction. There's no realistic way for law enforcement to take any action against them. And we're currently trying to negotiate that ransom down from $5 million to somewhere in the six figures, where it might be potentially possible for the municipality to pay. So the next thing that we turn to, and one of the first questions that I asked on the first day of this incident was, can I see your cyber liability insurance policy? And unfortunately, this municipality did not have cyber liability insurance, which otherwise might have covered the costs of the investigation, the remediation, and the payment of the ransom. So this municipality has really found itself in bad straits. Unfortunately, the lack of insurance means that it is on the hook for all of the costs, including the exorbitant and extortionary ransomware payment that's been demanded. And the lack of backup has left them unable to restore their systems. So hopefully, if you listen to that story, it's sort of a rogues gallery of what not to do, and might give you some anxiety about the possibility of your county or organization and the situation that you might find yourself in if you were afflicted with the same type of malware. I'll just share as an aside, we don't know exactly how that ransomware was delivered to that municipality's systems, but generally speaking, ransomware gets into your system when a worker at the municipality either responds to a phishing email and provides their login credentials, username and password, or clicks on a link or opens an attachment that contains the malware, which is then installed and able to spread throughout the system. I suspect in this instance, we probably had an employee who received a phishing email that appeared to be from a trusted source, like their bank, or perhaps even from the municipality's own IT department. So it looks like something that you should respond to and something that you should trust. It says that, we need you to log into your account to update some information, provides a link. If the employee is not careful in checking to see that that link leads where it says that it does, to the bank's website or to the municipality's own internal computer system, they instead are redirected to a spoofed web address. Might look like the bank, might look like the county IT system, but when they insert their username and password, they've now given up login credentials to the criminals, who are then able to use those credentials to log in just as the employee might remotely, and then get access to the file structure and install the malware. So that's my guess. We haven't completed our forensic investigation, but that's my speculation as to how this might have happened. So where does that bring us to in terms of cybersecurity contract terms? Number one, I think it raises an issue about the contract between the municipality and its IT vendor, and what representations the IT vendor made about the type of security that they would provide, the type of warranty or guarantees that were being provided under that contract, specifically whether they were required to back up the municipality's systems in any certain on any certain schedule, and what the relative liability of that vendor might be to the municipality for the costs of remediating this incident. And so with that, let's kind of apply that scenario to some of our common terms. So when you're negotiating a contract that relates to information security or information technology, the first stage of that negotiation should be conducting a risk assessment. And risk assessment is a complex term for figuring out exactly what information is at issue and what would happen if something went wrong in that vendor relationship. So for a county, you may have a variety of different segregated computer systems, one that's used for tax payments, one that's used for bill pay, another that stores voter identification information, and other internal systems that might not store sensitive information at all. You need to think about who is going to have access to the county's data, and what is the level of concern that you have if there were any sort of inadvertent or deliberate exposure of that information. And to walk through the liabilities, you've got state and federal laws that protect certain categories of personal information. At the federal level, you have protected health information under HIPAA, which might appear in your employment files. You have personal information such as social security numbers, taxpayer identification numbers, driver's license numbers that might appear in your employment files, but also in the files that you keep regarding the residents of the county, in applications that they submit for services and elsewhere. And then you have payment card information, credit card numbers, debit card numbers, and financial account information, checking account numbers, etc., that are protected by state breach notification laws and also by the credit card regulatory regime, the payment card industry data security standards. So when you're considering a vendor who's going to be storing or utilizing, processing your data on your behalf, you want to conduct that risk assessment and determine exactly what types of information are going to be under their purview and what is your potential exposure if there was a breach of that information. Good rule of thumb, generally speaking, a data security breach is going to cost about $250 per record that is exposed. So if you're looking to do a little back of the envelope calculation, if you have 100,000 residents in your county and you have a certain file that maybe voting records or residence records that have the social security numbers of each of those 100,000 residents, just use a round number, and there was a breach of that information. If you multiply out 100,000 times $200, you're looking at potential exposure of $20 million. That includes the costs of remediation, investigation, paying for lawyers to analyze your notification obligations, issuing the notification, and defending potential lawsuits that might arise from a data breach. So that's sort of an all-in number. In the municipal sector, they've broken that down a little further, and it's a little bit lower. It comes out to about $130 or $150 a record, but you're still looking at a substantial amount of exposure that can be relatively easily calculated based on the number of files and the number of unique individuals whose personal information appears in those files.
Hi, Devin. I'm just checking in. I was curious to see if anybody had any questions. I haven't seen any on chat other than the one I entered. And first of all, I wanted to ask you about the municipality you were talking about. And are they still down, or if they paid?
They are still down. They are taking a two-tiered approach. On one hand, we have our vendor trying to negotiate with the criminals to try to get that ransom down to a manageable number. And if they can get it down into the low six figures, I think they're very likely to consider paying the ransom. But meanwhile, they are hard at work with a lot of employee overtime, trying to reconstruct all of their payroll information and other accounts receivable and account payable information because there's certainly the chance that these criminals are not going to negotiate in good faith and get down to a reasonable number. There's always the possibility that they'll just ghost and not cease communication and leave the victim in the lurch. What we have done to try to establish the bona fides of the bad actors is our vendor has requested and received from them what we call proof of life. So, one thing you have to worry about in ransomware scenarios today is that the ransomware software, malware, is very easily obtainable on the dark web. You could have, a teenager who's interested in computer science and knows enough to get on the Tor browser and get on the dark web and go to a dark web marketplace, and they could download some variant of ransomware for a relatively limited price. And they could then attempt a phishing campaign, even without automating the process, just sending one email at a time until somebody takes the bait. But what we run into in those instances where you've got an inexperienced individual actor, they may not know what they're doing and may not even be able to decrypt the system if it comes to that. So one of the first things we do before we even start negotiating with cyber criminals is we will take one of the encrypted files off of the system, and we will provide that encrypted file to the bad guys and require that they decrypt that one file and send it back to us. And that's in order to prove that they've got a decryption key that works and the technological capabilities to unencrypt the system if the ransom is paid.
Okay, so Devin, here's a question from Leslie. She asks, is there a good rule to follow to determine the requirement for a vendor to provide cyber liability insurance with the contract? Should every vendor need this insurance to work with the county systems?
Yep. And let's, in fact, let's just jump ahead a page or two here, and we can talk about that particular issue. So, one of the primary issues that arises in the negotiation of these contracts is going to be the allocation of risk. So if you're a county, you want your vendor to take on as much responsibility as possible if their breach of contract results in this type of harm, whether it's ransomware, deletion of your information, or any other kind of failure that affects your ability to do business and move forward. So the vendor, on the other hand, very much wants to limit its liability. And it's not a zero-sum game. When you're negotiating these contracts, you can certainly understand that from a vendor's perspective, there are many, many things that can go wrong. And most IT security vendors, in fact, I don't know of any IT security vendor that's going to give you an absolute guarantee that your systems will never be hacked, right? Because the hackers are always working to develop new strategies, whether that's some sort of exploiting some sort of a defect in software, exploiting some failure to update software, or utilizing social engineering by manipulating people through phishing emails or otherwise to provide login credentials. And no matter how great your IT security vendor is, there's really no possibility that they can 100% prevent that kind of instance. And when you're talking about potentially $10, $20 million in liability, a vendor is going to be unwilling to take on that entire responsibility. So what we generally do is we will provide, what the vendor will generally propose is something very minimal. They'll say, we will limit our liability to the last 3 months of payments that you've made, or the last year of payments, which might be, really a pittance compared to that potential liability. So, neither party is going to be happy, and neither party has any real assurances unless you tie liability in the contract to cyber liability coverage. So what we've found in negotiating these contracts is that the most acceptable means for the parties to allocate their risk is to require one and or both parties to have cyber liability insurance coverage with adequate elements of coverage and an adequate amount of coverage to protect against these kind of risks. So the vendor contract might very well say that the vendor is liable for a breach of contract that causes harm to the county up to X number of dollars set between the parties in their negotiation. I'll just continue to use the $20 million number. You say that they're liable up to $20 million, but that amount is exclusively payable through the proceeds of a cyber liability insurance contract that they are required to obtain and provide a certificate of insurance to the county to add the county as an additional insured. There's a variety of different ways we can make sure that coverage applies.
It sounds like the municipality, or the example that you were giving us, they did not have a contract with their IT company, a cybersecurity contract of any sorts, nor did they have cybersecurity insurance. Is that correct?
That's exactly right. They had a contract. It was a very bare bones contract that essentially said we'll administer your network and set up your IT, but it had no guarantees and no warrants of performance. So that's another issue. We'll circle back here a little bit. What you want to have from a risk allocation perspective is you want to have requirements that they keep your data confidential if it's being stored on their systems. If they're providing a service like IT security, you want to have an indemnification provision that says that if there's a breach, they're responsible to indemnify you for the costs of remediation, which should include payment of ransomware, investigation, replacement of hardware, replacement of software, etc. So that's the indemnification language is critical to transfer the liability to the vendor. And again, once you have them willing to accept that liability, what they're going to tell you is, this would put us out of business if there were a breach. And so we can't just have an unlimited indemnification clause. And the way we resolve that is by including a limitation of liability to say they're only liable up to X amount, and to tie that limitation of liability provision to the amount of cyber liability insurance coverage that they have in place or can obtain.
And then another question. So how do you really know if a vendor has security measures in place and that they say, when they say that they're in place?
Sure. So here's a good example of a very customer-friendly provision for security controls. You can include language that says that the vendor will maintain effective information security controls, policies, and procedures to ensure the security and confidentiality of data, protect against anticipated threats to the security of that information, protect against unauthorized use or access, and ensure the proper disposal of the data and information. That's a pretty strong clause in favor of the customer and adverse to the vendor, that requires the vendor to take some pretty extreme steps. You may have the vendor balk at this language. What we find to be sort of the middle ground language would be something along the lines of, the vendor will protect the customer's information using the same degree of security that the vendor uses to protect its own information. So whatever steps the vendor utilizes to safeguard its own system, it's required to utilize those same steps to safeguard the system or the data that it's storing on behalf of the customer here at the county.
All right. Oh, we just got a message. We have a reminder that the breakout session will end at 1:30. We have three more minutes here, and to go back to the main website to log in. So with that, Devin, 2 more minutes. Is there any more information or advice that you'd like to give?
Sure. I think we've hit along the major points here. So I'll just sort of highlight those again, that you need to tie your contract terms to cyber liability insurance. You want to have an indemnification provision that transfers liability for a breach from the customer to the vendor. These are in instances where, again, either the vendor is providing your IT services and administering your network and therefore is responsible for protecting that network from intrusion, or in any situation where the vendor is storing your information, such as a cloud provider, if you're looking to host systems on a cloud service, where your data is going to be hosted somewhere else other than on your systems. In those circumstances as well, you'll want to have assurances from that cloud vendor that they have adequate safeguards in place to protect your data when it's hosted remotely. And you want to have an indemnification provision that provides that if they fail to meet those contractual guarantees to safeguard the data, they are responsible for the costs that are incurred. And because those costs can be essentially unlimited and unreasonable for a vendor to bear individually, generally speaking, you want to negotiate to tie a limitation of liability to the amount of insurance coverage that the vendor has. You'll want to ask the vendor to add your county as an additional insured on that cyber liability policy, or at a minimum, provide you with the certificate of insurance and a copy of the policy that shows the extent of coverage and shows you the amount of coverage. You want to look carefully at those liability policies, because issues like payment of ransomware, not always covered under every insurance policy. So look at the elements of coverage and make sure that that costs to pay a ransom and other costs of remediation and investigation are all within the scope of the policy.
All right. Well, thank you, Devin. Thank you so much. It's time to go back to the main conference. Appreciate your presentation. And I know the slides are going to be available, right?
Absolutely. Thank you, everyone.
Absolutely. All right. Thanks, everybody. See you back at the main conference.